I see we just give the last few people to join, then we'll start.
Okay, thank you.
Hello.
Hi, afternoon.
Good day.
Okay. Let's start. My watch says it's past. I'm sure other people will join us and when they are ready. Just to let you know, the last time we were supposed to record, and from our side there was a technical issue, so today this session will be recorded. I'll be sharing a slideshow with you, so I'll be putting off my video also just to make sure that there's no problem with the connectivity. Before I move on to the presentation, just to give you a quick rundown on that, just after this line or this course went online, the Department of Justice and Social Development introduced the Children's Act Amendment Bill to the Parliament. So those amendments haven't been signed off by Parliament, but they have been presented to Parliament. And I thought it would be good for us just to have a look at some of those amendments, because some of those amendments do speak to the material that you are currently working through. It's quite a lot. So what I've did is I'm dividing it in two. So tonight we will look at the amendments up until section 45. And then during our next webinar, I will look at the other amendments that follows for the rest of the Act. But before I move on to the amendments, I just want to sort of open up and see if there's questions with regards to anything else that you've been looking at, case law or anything like that you're struggling with. I don't know if there's any questions with regard to that. I see no hands from my side, so okay, then I will move on. So also just tell me, I'm gonna share the presentation with you. So I'm just gonna ask that someone just tells me when they can see the presentation, because sometimes it takes a time for the presentation to start. So let me just quickly start. If somebody can just tell me if they are seeing it. Okay, good. Okay, so you will see when we deal with some of the sections, I will refer back to the Act as it is currently. Otherwise, the amendment not necessarily won't make sense, so that we can just see the exact extent of the amendment. Also, keep in mind that some of the amendments, in terms of section 1 to 45, the amendments, I didn't necessarily highlight all of them, but there's some of them that are really not that extensive that you can go and have a look at. And this presentation that we'll be going through now will be uploaded also to your workspace, so that you can have it also just as an easy reference. I have the whole document, the whole amendment bill, I have a link to it. I will try to share it. And so that you can, if you want, download the whole children's amendment bill, if you want to do that. Okay, so let me just say that. Okay, so basically in terms of section 1, which deals with a lot of the definitions, they have changed the definition in terms of care, and you will know that care forms part of parental rights and responsibilities. So what they've done now, they've added some wording to that definition to say that somebody that is caring for a child must provide the child with a suitable place to live and live with living conditions that are conducive to the child's health, well-being, and development, and the necessary financial support. So I think a lot of times we deal with, especially in South Africa, where there's a big difference between the rich and the middle class and the poor. And sometimes the notion is that if you are poor, then, in terms of looking after children, maybe you cannot do that. But they've changed the definition to say a suitable place to live. So if the place is adequate, yes, it might not have 5 bedrooms and 3 bathrooms, but if it's suitable, there's a roof, there's beds, there's furniture, there's fridge, there's food, it's a suitable place to live, and living conditions that are conducive to the child's health, well-being, and development. So that is now part of the definition of care. They've also deleted the definition of divorce courts. And I'm sure there's some of you in the group that were practicing family law when we had the Central Divorce Court, the Northeastern Divorce Court, I can't even remember. But you will remember there was those divorce courts that were periodical courts that went around from town to town. And you'll see a lot of sections in the Act, they still refer to those divorce courts. So what they've done now is they've deleted divorce court or the definition of the divorce court out of the Children's Act. They've added a new definition that talks about separated migrant children or child. What does that child mean? It also links to what we were talking about, the undocumented children. So because it wasn't defined in the Act, they've now given it a definition. It means a child not a citizen of the Republic who has been separated from both parents or from previous legal or customary caregivers, but not necessarily from other adult family members, including a child accompanied by an adult family members. I think it's just, they found lots of times in the practice that there's a bit of a mystery about when do we deal with this kind of children. So giving it a definition will hopefully make it easier for the courts to decide when they are dealing with a child like that. So again, I've inserted section 6A. Sure, practice or service time to time have to deal with people that take photos of children, that make recordings of children, and I'm sure you are quite familiar with the practice of children being taken photos of when they come back from the other parent. Has to pose and that way, and photos are taken of every small scratch and bruise and I don't know what else. And then usually those photos are used in litigation, and there's been case law in any way along the way that says that especially where you take photos of a child's private parts or a naked photo of a child in a bath, those photos are not allowed in court proceedings. There has been case law to that effect, and the court can strike those photos from the pleadings. And also the argument behind that was that a lot of times pleadings are public documents. So what then would stop somebody from accessing a court file and then going through the papers, and then lo and behold, there's photos of a naked child or photos of sensitive areas of the child. So I think this section 6A come much from the experience a lot of times we have in the practice of a child just being taken photos of. So this specifically says the child has a right to privacy and protection of personal information, which is subject to the Films and Publication Act, the Protection of Personal Information, to Promotion of Access, Criminal Procedure Act, and any other law protecting the privacy and protection of personal information of the child. You will also remember the Children's Act talk about that in any way you will see in law reports, never ever in any way do you see the name of the child. It's always, they're always referred to as A or B or FL or MN. So in any way, that's always been the practice. Unfortunately, I can't remember the specific case now. Sometimes you get in these certain publications, they will publish a story, but they won't name the child. But if you read the story, it's quite easy to say 2 + 2 is 4, to come to the conclusion of who is the child. And the child has the right to privacy. And I think you can imagine a child having been identified in a certain way through a story, are then confronted by their friends at school or their friends at another place. And you know, children can be very cruel. So this is really to protect the children from their privacy and their protection of their personal information. Then section 7, that one is the one that deals with the best interest standard. So they have changed the last subsection, which says now which action or decision would avoid or minimize further legal or administrative proceedings in relation to the child. And then they've added a new subsection.
But al my boeke is nou daarin.
Sorry, can somebody just mute the microphone? Okay, thanks. And then inserting a new subsection that any special needs that a child might have. So if you then look at section 7, it still has that checklist of what is the best interest. But now they've added to the last one, they've added an O to deal with so looking at the special needs of the child, what will be in the child's best interest. And I was thinking about this a bit, and I was thinking a lot about, I think children nowadays, we get a lot to do with children that has special learning needs or special needs in terms of special medication that they must drink for their learning disability. Because a lot of times the Act would talk about a mental disability or a physical disability, which has a specific meaning. But the special needs is something else, I would say, where we have children with, I can never remember all the correct abbreviations, but with the attention deficit syndromes and those things. So they've now in O made it more specific that is something you need to look at when you decide what is in the best interest of a child in terms of section 7. Any questions so far? Okay. I can't see your hands while I'm sharing, so you'll have to speak up also if you have a question. Okay. So again, section 8, they added a section 8.4. Usually, previously the section stopped with 3. So they've added to say that this Act applies to every child in the Republic of South Africa. Again, I think this has come from practice, where there's been a lot of disputes about is the act applicable to foreign children, to migrant children, to unaccompanied, undocumented. So Section 8.4 just clarifies it that this act applies to every child in the Republic. And you'll see there's no proviso there. It's not a child born in South Africa, nothing like that. It's every child in South Africa. Sorry about that. My dogs are now just barking. Sorry about that one. So again, chapter 3 deals with parental rights and responsibilities. So you will remember that that is also the section where you will find section 21 that deals with unmarried. So what they've done now, you'll see, is there's a part 1 and a part 2 in the Act. But now what they've done is they made a part 1 and a part 1A. So part 1 deals with the automatic acquisitions of parental rights and responsibilities, and part 1A just with the acquisition. So you'll see, especially with part 1, you'll find that in part 1, you will find now section 21 with the parental rights of unmarried fathers. And you'll see, if we move on, that that is where the biggest amendment also now has come in. And I think there it will serve as, you know, just basically ended of the subsection 1. That you remember now, it will say that a biological father of a child does not have rights in respect of the child except, and then there's certain conditions, and those are the 1A, B, and C. So what they've done is they've amended or substituted some of those sections now. So currently 1A reads that if at the time of the child's birth he is living with the mother in a permanent life partnership. So what you'll see now is what they've done is to say at the time of the child's conception or birth, or any time between those two periods, they've been living in a permanent life partnership. So they've now added in the conception part of the child. So B, deals 2, which currently reads contribute or has attempted in good faith to contribute to the child's upbringing for a reasonable period. So I don't know, they've things just changed the wording of the numbering of those paragraphs. And then also contribute or has attempted to in good faith to contribute towards the expenses in connection with the maintenance of the child for a reasonable period. A lot of times I know in practice we get a question about this, about the maintenance. How do you prove that you have in good faith tried to contribute towards maintenance? And I've always said to a lot of the fathers is to say, well, open a post bank account, open a Capitec account, and say that I've tried to give the money to the mother and she doesn't want to accept it, so I'm now putting in my 200 Rand or 300 Rand or 500 Rand into the account. So if there's a question of have you been trying to contribute, you can say, well, yes, I have, but she didn't want to take it, so I've been putting it away. So there's an attempt in good faith to contribute. So they've inserted 21, one big A, into the section which reads to give the family advocate the authority to issue in a prescribed manner a certificate that the biological father automatically acquired full parental rights and responsibility. Again, this is, I think that comes from practice, is that how do you, I know the people a lot of times say, but yes, I tick all those little subsections. I've contributed, I've stayed together, but how do I prove it? So 21(1)(a), in my opinion, would be an effort to put some kind of proof to that. So the family advocate can now issue a certificate to say that the father has automatically required these rights. So that application can be made by the mother or the father jointly, by the father after reaching an agreement, the father after trying to mediate, but the mother has unreasonably refused, and the father has shown to the family advocate that he complies or that he meets those requirements, and therefore he automatically acquired those rights. Again, I think a lot of these subsections come from the practically, or the difficulties we have been experiencing since the Act was put in place. And I think they are hoping to try to see if they can't resolve some of the issues. Because a lot of times the father would, I know the unmarried fathers would say, but I tried to mediate and I would try to mediate and I've called for mediation, but the mother doesn't want to come to the table. So I think hopefully that will then now try and alleviate that problem. If the family advocate, yes.
Hi, sorry about this. So this obviously applies in divorce or a splitting of a relationship. What about when the mother's deceased and, you know, there's guardianship issues?
So no, so Section 21 deals with only unmarried fathers. So this one is only for...
In the case of divorce, not in the case of where there's the one partner is deceased.
Yeah, no, but that's why I say Section 21 only deals with unmarried fathers, not where... you mean if he's an unmarried father and the mother passes away?
Exactly, and the father needs guardianship.
Sorry, I misunderstood. Well, I mean, yeah, the Act doesn't now say, for example, I suppose one would want to say that they should have maybe there where it talks about mediation and the mother unreasonably refusing, maybe they have put in the mother and or her family maybe, which now they haven't. But again, it seems there is a discretion that the family advocate still has, that the father can present them with evidence and then they can make a decision that looking at all the evidence, the father have acquired the right automatically, which would then not need the family of the deceased mother to cooperate.
Okay.
I don't know
Thank you. It's complicated. Yeah. Thank you.
Yeah. I think really, yeah, I didn't, before you raised it, I didn't even think of that scenario, but a lot of times you're correct. A lot of times the unmarried father's problem comes after the death of the mother, not necessarily, you know, while she is still alive. But I think hopefully, yeah, and the amendment does not say how the family advocate will do this, let's call it investigation. You know, one foresee that maybe they're going to do a kind of investigation like they do now. So, yeah, and in the terms of the family advocate and the office in their capacity, yeah, I don't know how effective this will be, but at least if accepted, it will maybe alleviate some of the problems we are experiencing. Okay, any other questions? Okay, so then again, in terms of Section 22, they've inserted a 22(2) big A, because 22 deals with parental rights responsibility agreements. So they've inserted 2A that says that the child who is the subject of that agreement must be given the opportunity to express his or her views regarding the content of that agreement if he or she is of a sufficient maturity and mental capacity. Again, these kind of provisions never, in my opinion, go far enough because, okay, the child must be given an opportunity. So how is the child going to be given an opportunity? So who is going to put the child down and talk to this child? Because what they've done also with parenting plans and parental rights responsibility agreement, there's a, what do you want to call it, sort of a, they think that all agreements follow mediation, which is not necessarily true, because a lot of time people don't have money for mediations. They don't have money to go to FAMSA or any other institution, and the family advocate, with the greatest of respect, do not have the capacity to deal with all of this. So how is the child going to be given this opportunity? It was interesting, about 2 years ago, I was listening to a French lawyer, and they have a system of a child being part of a divorce proceeding almost from day one. And their procedure demands, or the rules are, that the child is taken to a magistrate at the time that the divorce is starting, and the child gives almost like a statement to that magistrate then about what the child wants. So in terms of their processes, the child is part of the process, and the views of the child is part of the process from day one. But in South Africa, child participation is very much still something that a lot of people are struggling with, and the natural inclination is not for children to be given voices in terms of divorce. There's more an inclination still of, no, we'll do the divorce and the child must just follow. So I think in principle this is a good thing. I just question the practicality of it in terms of how it is going to be done. So then Section 30 currently deals with co-holders of parental rights and responsibilities, which says that more than one person can hold parental rights and responsibilities. So the amendment suggests a new section, Section 30A, that says the following: parents must agree on the residence of a child. The residence must be determined in accordance with the best interest and may include a residence with both parents where the parents are living together, a residence with one parent. The residence with one parent will not affect joint exercising of parental rights responsibilities, and if there's a dispute, that must be referred for mediation before approaching a relevant court. Again, I think this section was introduced because of issues we are experiencing in practice. Of parental rights responsibilities, acting on his or her own without acknowledging the other holder's rights. So I think this was an effort again to sort of spell out what does it mean to be a co-holder of parental rights responsibility. It means that the parents must agree on the residence of a child. And again, I think specifically that's also why they say if the child is residing with the one parent, it doesn't mean that it takes away the rights of the other parent. Both parents must agree on the residency of a child. I know
Sorry to interrupt.
that's fine.
I just want to ask then, is this implying that there has to be a primary residence versus half-half? You know, if you were doing the joint rule.
Well, I don't see. Well, I think first of all, because residency was never part of the definition of parental rights and responsibilities. I also see this is why they brought it in. So residence is now part of parental rights responsibilities and has been given, you know, it's named. There must be an agreement. But I don't see that this one excludes joint residency, because the parents must agree on the residence of a child. So if they agree, the child stays with you for 30 days and for me with 30 days. I don't see that 30A excludes that they cannot agree on that, because that will surely be by agreement that there will be joint residency.
Okay, perfect. Thank you.
Yeah, I think this was also, and I'm sure all of you that are either social workers or lawyers know that there is still this kind of proprietary inclination by a parent that is the primary caregiver, that if I'm the primary caregiver, I can decide where we're going to stay, where we want this and that. So I think this is also an effort to sort of say to everybody, yes, no, you're the primary caregiver, but you cannot just decide on how and where and what. We are both holders of parental rights and responsibilities, and therefore we must agree what and how and where our child is going to stay. The other thing, and I don't know, I know we have people from KZN here and from Limpopo, Mpumalanga. I know in the Children's Court in Pretoria, nowadays, they're getting very sticky about this mediation. They enforcing it, and to say that if this is purely a parental rights responsibility dispute, you must be able to prove to the court that you've tried mediation. So you must have some kind of outcome. So I don't know in your jurisdictions where you are practicing, if the Children's Court and the High Court, if they really bother with this, or if they just hear any matter that comes to court. I don't know, the lady from KZN, is she here? She's not with.
I am here. I am here.
Okay. Now, I just remember you were saying you were in the rural areas of KZN. So do they bother with mediation, or can you just go to court?
So you just go to the court, but also what my experience has been is that because I'm deeply in the rural areas, they tend to less actually approach the courts, and a lot of the stuff is actually dealt with in the traditional courts.
Okay. Yeah, which is in any way a bit more with like a mediation, you know.
Yes.
So
yeah. So they'll go there, and then like afterwards, then they may approach the courts.
Okay. Yeah, I think also the Children's Court in the bigger urban areas, they need to in some way filter the matters that are coming to court. And I think that's also what they use this section to say, but first go and mediate. Don't just run to court. First try to resolve it yourself. So it will be interesting to see how strict they are in going forward.
Elizabeth?
Yeah.
Yeah, who is then allowed to do the mediation? Does it have to be someone that is registered as a mediator, or can it be an attorney?
It says, let me quickly find it. It does give you again that same sort of, you know, that list that they always give you, the social worker, qualified. Let me quickly find it. Where is that one now? It again talks about a social worker and that's suitably qualified, you know. Yeah, it says here, for mediation to a family advocate, social worker, or such other suitably qualified person as may be prescribed. So usually that qualified person is usually then somebody, I think the regulations talk about, you know, somebody that must have some kind of experience in terms of being a mediator. So attorneys are not excluded in terms of being possible mediators.
Thank you.
Okay. So section 35, you will remember that forms part of the offences and refusals of contravening court orders. So they've amended it to say that person refusing access in terms of an agreement or parenting plan is guilty of an offence. Which again, I think is just sort of stating the obvious, but I mean, there is a lot of issues with it. And then again, it says that a person having contact rights must, in terms of an agreement or parenting plan, must be informed by the other holder of any change of address. Again, I think in practice, this is something that it's not happening. I think all of us deal with a lot of here. I find that the person is just being informed I've moved, the child is. So this is now part of offences or the contraventions that the Children's Court can have as offence. Again, I think again from jurisdiction to jurisdiction this differs. Some Children's Court are willing to entertain contempt proceedings. Others don't. They would do anything but go into any kind of contempt proceeding or investigation. So again, I think that each of us will have a different story on if it works or if it doesn't work, but it's now been spelled out also a bit more clearly. Okay, so section 45, well, you'll remember that deals with the matters a Children's Court may adjudicate. So they've added now a paragraph 1B big A that says a Children's Court can adjudicate guardianship applications for orphaned or abandoned children as contemplated in section 24. And section 24 deals with your guardianship application. So now, because this is now new, they've now given the Children's Court jurisdiction to deal with guardianship matters with regards orphaned and abandoned children, which again makes sense, because if there's an orphaned or abandoned child, who on earth is going to go to the High Court? Who's going to have the money to go to the High Court to apply for guardianship? So that, I think, it's an important practical thing that they should have changed a long time ago. But if you talk to the people that wrote the Act, they said there was, for some reason or another, there was a big reluctance when they initially introduced guardianship. They wanted to say the Children's Court can do guardianship matters, and they say that there was a big reluctance and a big hoo-ha to say that no. The Children's Court cannot do guardianship matters, only the High Court. So I'm really glad to see that we are moving towards the Children's Court dealing with that, because it's just much cheaper and just more expedient, I think, at the end of the day, than going through the High Court. And then they're inserting section 1J big A of matters that the Children's Court can adjudicate. They can adjudicate matters involving an unaccompanied or separated migrant child, or a child who is an asylum seeker or refuge, as contemplated in the Refugee Act. Again, I think it speaks to the sort of just the vagueness that it was there around the undocumented children, the abandoned children. You don't know who they're from, who they're with. So again, it's just a bit of clarity to deal with that. So then subsection 2, they substituted with the new subsection 2 that says the Children's Court must refer any criminal matter arising from the non-compliance with an order or a charge relation to any offence in section 305 to a criminal court. So they cannot sentence. This is what I understand. So if they do the inquiry and then is a non-compliance, they themselves cannot do the sentencing. They must refer that matter to the relevant criminal court that have jurisdiction, which I think in most cases would be a district court that will then look into the criminal aspect of the offence. So yeah, this part becomes a bit confusing. So
sorry,
I'll try
can
to.
I ask? May I ask a question? Somebody asked it in the. Somebody asked in the chat whether this has already been implemented or when it's going to be implemented.
No, the last notification I got was that it was presented to Parliament. We have not yet received any feedback that it was accepted.
Okay, thank you.
Okay. But I think also I was just thinking that yes, it might not be implemented yet, but I think it's important for us to know that if somebody signs it somewhere, we know that what we can now do maybe and what we should do differently in terms of especially the Children's Court and so on. So, and then 45(3) A and B but is now deleted. So I just want to say that what it says, I'm going to read it. So pending the establishment of family courts, the High Court have exclusive jurisdiction over the following matters. Then A currently reads guardianship and B reads the assignment or the exercising or the termination of guardianship. So those two, A and B, they want to now delete. But then the one that deals with surrogate motherhood exclusively stays with the High Court. So only the High Court still can deal with surrogate agreements. Then inserting 3 big A and 3 big B say that the High Court and the Children's Court have concurrent jurisdiction over the guardianship of a child. And also then the High Court, the Children's Court, and the Regional Court has concurrent jurisdiction over the assignment, exercise, extension, or the restriction or termination of guardianship in respect of a child. I think in terms of the last one, the 3B, why they've inserted the Regional Court there, is that I think always the question is that a lot of times in agreements, they talk about parental rights responsibilities, which, as the definition now stands, includes guardianship. So, strictly speaking, a regional court would not have been able to amend or extend or restrict or suspend guardianship in terms of a divorce order that was made in the High Court.
Sorry, Elizabeth.
Mm-hmm.
Sorry, I have a question. Sorry to cut you there.
No.
Okay, so if the Children's Court is going to have jurisdiction to entertain matters concerning guardianship, does that now take away the concept that the High Court is the upper guardian?
No. Mm-hmm. The High Court will always be the upper guardian of children. So that is also a common law jurisdiction that the High Court has, is inherent jurisdiction. So no, that doesn't, the Act cannot take away that. So the High Court, for example, still will deal with, you'll see the other subsections in Section 3 stands in terms of the removal of a child from the country, any property of the child, artificial fertilization, those things stay exclusively the jurisdiction of the High Court as upper guardian. The reason, and if you go back into the history and the practicality of guardianship, a lot of times guardianship comes up for children that loses a parent, or parents, and now they must stay with an aunt, a granny, and I think all of us know, in terms of the High Court, the expense and just the difficulty bringing an application in the High Court. So this is really, I think, the following on years and years of pleading of a lot of people to say, please give the Children's Court jurisdiction to deal with guardianship. But no, it doesn't take away the High Court's jurisdiction as upper guardian of children.
Okay, and just one last question. You dealt with criminal matters being entertained in the Children's Court now. Does that mean now is play offences that are committed by children will be heard at the Children's Court exclusively?
No, don't. The Children's Court, you mustn't confuse it with the Child Justice Court. Because what you're now talking about is children in conflict with the law. So what that amendment is saying is that if there's a non-compliance with an order of the court, and the court has now done an inquiry into the non-compliance, and they found that the person is in contempt or has committed an offence, that must be then referred to a criminal court to then deal with the offence of contravening a court order of non-compliance with a section of the Children's Act.
Okay, thank you.
Okay. So I think, I think hopefully these amendments, especially the ones dealing with the High Court, is really, and the guardianship, is really going to make just life a lot easier in terms of helping people that are struggling with guardianship. Okay, any questions?
Is there anything that addresses the gap between a court order, in other words, a parenting plan that's been implemented by a divorce or at the time of a divorce, and the time before the divorce when the child's access is where the father's access is being denied?
No, because the sections talk
other
about
than a Rule 43.
No, well, I mean, that amendment that they put in terms of section, let me just quickly get that section. Well, if you look at the new section 38, or 30A, I'm just quickly thinking as you're asking, that I wonder, because look, if parents are equal holders of parental rights responsibilities.
Yeah.
With or without a court order. I mean, that
Yes.
The Act says, as a parent, as a mother, as a father, I am the holder of parental rights responsibilities, which has a natural consequence.
Correct.
But because this then would say that parents must agree on residence. For example, I'm looking at now this. So there's nothing here that says there must be a court order or a parenting plan or an agreement.
But if one parent withholds the child from, addresses that chasm before the divorce is actually finalized, where you can compel one to do what they're required to do because there's no actual agreement in place. I know that they both have parental rights, I've got a case like that. I'm not a lawyer. I'm a social worker, and I've got a case where exactly that is happening. The mother has withheld the child for a year from any contact with the father for no rhyme or reason, other than she doesn't want to bother. And this, other than a Rule 43 for which the father doesn't have money to address this, that I can figure out.
But why are they married? So there's a divorce, or are they not married?
They're married.
Yeah. You see, the problem is that strictly speaking, yeah, I see, because you should. Yeah, I understand the problem because he doesn't have the money. Is it? I suppose it's also pending in the High Court.
Yes.
Yeah, you see, the Children's Court is not going to have jurisdiction because there's a pending.
Yes, but now your Afrikaner case, which can one not claim that the child is being abused by not being allowed to have contact with her father?
You can, I'm sure an argument can be made. I think it's a bit far-fetched. You mean that it's kind of an emotional, emotional abuse? You know, I think it's dicey. It's a bit thin ice, because you will clearly be able. You'll have to make out a case of some kind of abuse. I mean, just saying it is not gonna, it's not gonna make it so. So I'm hesitant to say. Well, I mean, yeah, I just think that it might, it might not be a good argument. But I see there's colleagues here that have their hands up, so I'm sure that might be. I have Lerato, your hand was first, and then I have Patrick, and then Chantal. So yeah, first Lerato.
Okay, hi. On the issue of a mother who is frustrating the contact, isn't it so that the child has the right to contact with both parents? So couldn't you make an argument now using the child instead of looking at the two adults who are now fighting over the child? The child has that right to maintain contact with both the parents. So that
yes,
that's
kind of the case I'm trying to make, in that her rights are being are not being upheld, and that she's being abused by not having access to a father who she loves.
Yes.
Yeah. You see, I think if you're going to say it's the child, the child will have to be the one that's sort of making the application, maybe. But I mean, that's not going to work in your case. Okay.
Would it work? Would it work to appoint a lawyer for the child in that case?
It can, so that the child has their own voice. Yes, that can work.
Thank you,
Patrick.
Oh, sorry, I'm using my colleague's.
Oh, okay, sorry. Okay, so the person playing the role of Patrick.
Yes. So I have a question regarding the best interests of the child, and also section 21 regarding unmarried fathers. So if we have a situation whereby we have a child who is 14 years of age, who refuses to have any contact whatsoever with the father, and you can clearly see that there is some form of parental alienation. And also the mother says she's not going to get involved, she's not going to force the child to have contact with the father. What do we do there? Because I know that we have to take into account the wishes and views of the child. But now, are we going to be governed by That's my issue to say. If a child says, look, I don't want to have access with my mother or my father, are we going to listen to that child? Because at the end of the day, they are still children and they don't know what is in their best interest. What happens there?
Yeah, well, you're asking the wrong person. I'm currently sitting with 4 of those children as clients who is saying to me, I don't want to see my mother, I want to see my father. And the reasons, if I put on an adult hat and if I look at an ideal world and if I just look at it black and white, I might say, yes, they're children and we should not listen to them. But they're 14, 15, 16 years old. I always say to the people now, what do you want me to do? If the 14-year-old says, I do not want to see my father, what do you want to do? Drag the 14-year-old and put them in a car and make them go there? Because the people like Karen and the social workers and the psychologists will tell you that if there is alienation, 14 is too old. If you want to undo alienation, you must get the children before, 10 or 11. Then you must remove them from the parent that is alienating, place them, not necessarily with the other parent, but neutrally, and then actively deal with them in therapy to undo alienation. So in terms of a 14-year-old, not so much. So I'm maybe the wrong person to ask. And if you, a lot of times, if you give that 14 or 15-year-old a legal representative, a lot of times you'll find that their reasons are sound for them. So are we now going to say, no, because you're 14, no, your reasons are stupid. So just go and sit in the corner like a good puppy and shush now. And we, the adults, we will decide over your life, because that is contrary to what the whole Children's Act is about. The Children's Act is surely there to say, you as a child, we must listen to you. Yes, and I know the next thing my colleagues usually say, yeah, but are we now going to take the child out of school because they don't like school? No, nonsense. No, we're not going to do that. But surely where it is about seeing a parent, living with a parent, is it so terrible to listen to a child that says, I don't want to see my parent.
Oh, okay. I understand.
So you're asking the wrong person.
Okay, thank you.
I'm fighting for these children, and really a lot of times. And you know what, also, I think we as a society are also reaping the fruits of our own, I don't know what we want to call it, because children nowadays also is very much about, especially the teenagers. I usually say to the court is, I think a lot of times children nowadays look at the other parent and they go like, you know, I don't like you. I really don't like you. You awkward, you like, and then I think they go like, but I don't like you, and why should I spend time with you? And then what do you say to that child? No, you must, because he's your father or she's your mother. I don't know. Chantal also had a hand. I see your hand was next, Chantal.
Yes, actually I've two things that I want to comment on. The thing with Karen, firstly, she spoke about a Rule 43 being in place. And if that Rule 43 provides custody or visitation rights and such, isn't it a contempt of court if someone breaches a Rule 43?
No, it is a contempt. I mean, if there's an existing order, then it's easier to enforce. But I think she says that's the problem. There is no orders of any kind.
Sorry, there was a Rule 43, but for some reason it only covered 6 visits, and they were supposed to be supervised, and they were not supervised. And then the 7th visit, which was not on the Rule 43, the mother approached me to supervise the access. And after that, I obviously gave a very positive report because the child and the father adore each other, and the mother never wanted them to speak to each other again. And from then on, that was the end of the story. So the Rule 43 has expired. It doesn't. It's not
it doesn't
valid
cover it
anymore. Yeah.
Okay.
And can
Okay,
he not go
Chantal?
back to court to continue with the Rule 43 or get a new Rule 43 in place?
The client can't afford.
Pro bono, legal aid, anything.
Can't have pro bono because he has income that exceeds 7,000.
Oh, jeez. But
Yeah.
even, you know, they don't recommend it, but he can go to the court himself. He doesn't have to have an attorney. They just don't recommend you go that route. But he can do it himself.
Yeah, it's a very complicated, but it's been tried. We've tried the Children's Court. We've now raised funds for him to have another Rule 43 in place, but I just think there should be some other remedy. But, you know, there should be some other remedy. So now we're going to try, like this Afrikaner case, we're going to try that.
Okay. You had another question, Chantal?
Yeah, the same thing I wanted to comment on was now children having a say in their matters and such. And I think something like that, the court would actually look at what's reasonable as well. Because we've all been teenagers, we've all thought that we know better than our parents, and we really don't. And they are 14-year-olds who throw a tantrum because they don't want to visit daddy, because daddy wants them to be outside and not on the TV all day. And something like that isn't reasonable. I think the court would look at that and be like, okay, you know, this child doesn't want to go to dad because they have to be outside. I think they would look at the fact of, you know, this child, if they don't want to go to their other parent because of abuse or because of severe drinking, that is something that they would listen to, but not something like that the child doesn't want to go just because they don't feel like it.
Yeah. I think that's also where it becomes very important, this whole thing of children having legal representation. Because then they have somebody that's there to give their voice. And I think a lot of times the children also get frustrated because they will tell mother or they will tell father this is my wish, but because it comes via a parent, it just becomes part of the bigger fight. And I think that's where it becomes important that children have their own legal representation. So it's their voices, not via a mother or a father.
Yes, I think that's definitely important. But in cases where they say, I don't want to go visit my other parent anymore because of silly reasons, I think things like that, they would actually look at and just decide that this isn't a valid explanation. So the child can be heard, but not over something silly.
Yeah, no. I think that's what it's with each child and each circumstances, you know, I agree. Sometimes it can be silly. And I find a lot of times with the teenagers, sometimes they are just stubborn because they want to be heard. I have a child now that one day refused to go back to her father. And when I consulted with her, she said, no, she wasn't really refusing, but she felt so frustrated in the process because nobody was listening to her. And she was just like raising the flag now and saying, you please listen to me. And, you know, we walking the road now. She went back to her father, but we must just first listen, and then before we decide, no, they're just being rebellious.
Yeah.
Now it's difficult for me to see who was next, but I have Nobu.
Yes, thank you. So my, I guess, question / thought is, in my work in rural KZN, we are always trying to discuss the rights of the child and these types of things. And I'm looking at these amendments, and we do a lot of training with traditional leaders in the traditional court. And just as a thought is that often I feel like I live in two worlds, because I'm sitting here where you have this conversation, you know, children are individuals, they have rights and thoughts like that, but the reality is a very large portion of South Africans who don't live in metropolitan urban areas have very different realities. And I'm always wondering, when I read the Children's Act, I feel like it takes very little recognition or cognizance of African culture
Mm.
as it relates to how children form a part of a family, because it's very individualistic and takes away the community element of children and family. And so just all of this, it's just a thought that
no, it's true. I'm sharing my own experience. I'm currently also working in the Tembisa Children's Court, and from years working in the Pretoria Children's Court and the Pretoria High Court, where we have endless investigations and assessments, and it's like you know how those investigations work. And then I went to the Tembisa Children's Court, and there was this dispute, and then I was like, oh, okay, we're now going to postpone for assessments and whatever. And the magistrate, I said, no, okay, no, you go and testify. You're going to testify. Bring the granny, bring the aunt, bring the and I was like, okay. But what you say is true also. Why can we not resolve the child's issue by bringing everyone? Let everybody come and tell a story and decide. So no, I really agree with you. Deborah, I think there was a Deborah's hand up.
Yes, thank you for the opportunity. I think the one thing that seems to come out of all this discussion, and it hasn't been put into one call, is the issue of parental alienation. I've done a hell of a lot of research, but it all comes from international research. And is there a chance? Is there an idea that we're going to, consider parental alienation? Is that something that the courts are going to start slowly but surely, obviously, considering when they look at like the one lady said, the child hasn't seen his or her father for a year. I mean, parental alienation and how the one parent can indoctrinate the child to say, oh no, you don't want to go to the father. Oh, the father's like this and the father's like that. Is there a hope that we're going to be considering parental alienation in this country?
I don't see in the amendments the specific wording. So I think we're still with it being trying to define it under emotional abuse, under psychological abuse. So yes, I hear your cry, but I don't see it in these round of amendments that they're giving it those specific words. So maybe I think in years to come, but I don't think now with these amendments, no. Okay.
All right, thanks.
Okay, so yes, it will make our life much easier. Then I see a Janice. Your hand is up.
Yes, thank you for the opportunity. So I just want to mention one other point on giving the child a voice, that obviously it's very important and the child needs to be heard and their experience of their reality. But we also need to be very careful not to give the child the responsibility of making the choice of, I want to be with this parent or that parent, because that leads to a lot of guilt on the child's part down the line. And it's not fair on the child to be making such a call. The dispute and the divorce and the everything is an adult domain, which obviously affects the child, but we need to be careful not to make them responsible for having or not having a relationship with one or other parent.
Okay. I think, Janice, you said the last time you also associate.
Yes, I am.
Okay. Okay, no, because this is a theme. I've had many an argument. So yeah, but I mean, yeah, in terms of psychological health and development of the child, I know that from the social workers and the psychologists, they always sort of just warn us to not, if you want that answer from the child, don't ask it like that. Don't ask the child, where do you want to stay? Now, if you want to find out, do it in a more subtle way at the end of the day. Almarie, I see your hand is up.
Yes, I have two questions. The first one deals with damages in respect of the customary law. If you can maybe just explain to me where that comes from. And the second one is just what is the difference between an ordinary parenting plan and a parental rights and responsibility plan?
Okay. So usually how I differentiate the parenting plan and the parental rights responsibility agreement is a parenting plan is exactly what it says. It's a parenting plan. So it's a plan between two parents. The parental rights responsibility agreement is more something that you can, it's between you and somebody that's not a parent. So a parent can give his or her parental rights to a granny, to an aunt, to an uncle, and then there's a bigger agreement, which is then the parental rights responsibility agreement. You will also see in the Children's Act, there's different forms, and the parental rights responsibility agreement form, you will see, makes provision for holder 1, holder 2, holder 3. So that idea of sharing a parental rights responsibility, I think typically the idea was that maybe the parents will agree that the child will go and stay in a different province with a different person. And then that agreement will say, okay, my child is not staying with us, but it's going to stay with somebody else. And therefore, let's make an agreement to say, how are we going to deal with this child? So that's the parental rights responsibility agreement. In terms of damages, I'm going to tell you what my understanding is, and I'm sure there's people that might jump in and tell me a bit more. But damages is how I understand it. The other day I had a conversation with a nurse, and she said that she got pregnant out of before they got married, and her family required the father of the child to pay damages in the amount of, I think she said 15,000 rand, as then in terms of the traditional law, they must pay because the child was born without any kind of marriage in place or lobola being paid. If I understood Tan correctly, I'm stand to be corrected also if somebody wants to correct me.
I'll just add, that's basically it. But the purpose of inhlawulo, which is, I suppose, loosely translated as damages, is if you get pregnant out of wedlock, and it ensures that the father is able to claim his parental rights over that child. The child can take the father's surname and all traditional rights of introducing the child to her father's ancestors and all those things. Those ceremonies can take place once that payment has been made.
Okay, it's almost like you must show a commitment, otherwise just go away and don't come and bother us, kind of thing, almost.
Sorry, Elizabeth, can I ask, is the parental rights, responsibilities and rights agreement is used in an unmarried father when you're drawing up, in inverted commas, a parental plan between a mother and an unmarried father, am I correct?
Yeah, a parenting plan doesn't have to be between married or divorced people. A parenting plan is between two parents. So it doesn't matter if they're married or not.
I mean, already they automatically acquire those rights. I know the amendment makes it even more clear, but already the father acquires the rights if he's been living with the mother. Do you not still then do a rights and responsibility agreement? Do you just do a parenting plan?
You just do a parenting plan because the parents must agree on how they're going to exercise their parental rights and responsibilities. Okay, that's the purpose of a parenting plan. Yeah.
Thank you.
Okay. I'm trying to see other people's hands. I just want to, Deborah, are you done with the questions? Because I see your hand is still up. Do you have another question? Janice, another question? Because your hand is still up. Okay. Patrick, you have another question? Because your hand is still up. Okay, then I have Stephanie. I see your hand was up.
Hi, yes, thank you so much. I have a similar
case in terms of a child not wanting to have contact with the father. However, the child is 7 years old. From the investigation that the social work has done, we can't see parental alienation on either side. The mother actively encourages the child to spend time with the father, but every time the father comes to collect the child, there is snot and trane, and it's extremely traumatic for the child. And that's when the mother sort of breaks down, because she struggles with that moment of seeing the child being forced into the car, and you know how these things take place. And so in that case, the social worker said, no, he's too young to give his to give his opinion. And I felt that the mother being my client, I felt that in speaking with the child, that his reasons were actually quite valid. You know, they weren't like dad's boring or whatever. They were things like, you know, I have school things on the weekend and dad won't take me. And dad doesn't put food in the fridge and I get hungry at dad's house. And, you know, things like that. So I felt that they were quite valid reasons. You know, he often leaves the children with a next door neighbor instead of actually spending time with them. So in that case, I don't know what you would think of that, because for me, I felt like even though he was 7, he approached the matter in a very mature way, and his reasons were very valid. And I felt that he should have been given.
Yeah. Look, remember, if you look at section 10, it talks about age, maturity, and stage of development. There's no different age that's listed.
Yeah.
And maturity is what, I mean, if you look at the definition of maturity, is consistency, kind of a wisdom, kind of understanding. So, I mean, there is nothing in section 10 that says a child of 7 cannot consult with a lawyer and cannot give an opinion. And I think that's the danger, that everybody wants to have like an age, you know. It must be 7, it must be 5, it must be 8, it must be 9. But I mean, I've had a little girl as a client. I was her lawyer when she was 6. And we made wonderful plans, which worked. But I mean, I think the secret is that whoever you appoint must be able to, on a level of a 6-year-old, have a conversation and like Janice said, not like sit you down and say, okay, tell me now, what do you want? You know, that because that is 6-year-old is, and that's not what you do. But I really, for me, and I'm very passionate about this, is this belief that a child of 8 or 7 or 6 cannot have an opinion. And I think that's just dangerous, because now you have that child that is going through this, and nobody wants to say, okay, now, but let's get you a lawyer to help you, because no, the child is 7. You know, but I think it's we're getting there. I mean, I think it's still just old habits that, but I think it would be a wonderful solution if you can get a lawyer for that child, and you know, we can, it can go that way.
Thanks. And just following on from that, the same client in the middle of this has asked me quite an interesting question, which is whether she can put in her last will and testament that her parental rights and responsibilities would then be transferred to her mother or her father upon her death, because her fear is that she dies and the child is then forced to live with the father permanently.
Unfortunately, the Act is quite clear. It says that only if you're the sole holder of parental rights responsibility can you give it to somebody else. Unfortunately, and she's not the sole holder of parental rights and responsibilities.
Okay, thank you so much.
Okay, then I see Leander. I see your hand has been up for a while.
Hi, my question is completely off topic and very different. you mentioned earlier with regards to the High Court being the upper guardian of when it comes to fertilized embryos. I have a client who has fertilized embryos with her ex-husband, and she now wants to use these embryos. They were part of a court order where the embryos were supposed to be destroyed. They weren't destroyed, and she has subsequently found somebody else who wants to marry her, and they want to use the embryos. My question is the ex-husband who had fertilized the embryos, who sperm fertilized the embryos, doesn't want any part of the child who is then born therefrom, and the new guy wants to adopt the children born from the fertilized embryos. When can he adopt, and where do I go to? Would that be a High Court application, and can he then adopt fertilized embryos as his children, or do the children need to be born first for him to be able to adopt?
No, you can only adopt a child.
Yeah.
With the artificial insemination, I will have, and then I'll get back to you, because I'll have to quickly go and have a look at that section. But from memory, if I remember correctly, the fact that you donated sperm does not necessarily give you rights. So
Yeah.
I don't think there's something there, but he would have to adopt only once the child is alive.
Right.
But on the other hand, if they are married, there's also the presumption that the child is yours because you were married to the mother at the time of the
But we know
birth.
that they're not his because it's not his
Yeah,
sperm.
no.
Yeah.
Yeah. So do me a favor. I'm going to
Yes.
just post this question on the forum so I can just go and look at that specific sections again in the Children's Act, and I can give you a proper answer.
Okay. Thank you very much.
Okay. Then I have one more hand that's raised. It says Tess. Oh, it's Tess' hand's not raised. Tess? Okay.
Can you hear me? Oh God.
Then for it. Ah, okay, good. Okay, guys, then thank you very much for a very good discussion. I will then prepare a presentation for the other amendments. Oh, Tess is back. Yes, Tess.
Can you hear me?
Now I can hear you, yes.
Okay, great. I just wanted to ask a few questions, just following up on some people's questions as well. I missed the part in Karen's situation where she was discussing obviously the complexities of her matter, and you said that the Children's Court doesn't have jurisdiction, but I didn't catch why it didn't have jurisdiction in the matter.
Well, it says section 1.4 specifically says that any matter arising, or Children's Court doesn't have jurisdiction over any matter that arises from a divorce or pending.
So was there a divorce pending? I didn't catch. Okay.
Yeah. So there's a divorce pending, and then there's, except that that Afrikaner matter that I gave you a copy of as part of the training material, the short and the long of that is that if you can make out a case that the child is a child in need of care, even though there's a divorce pending, you can approach the Children's Court. Yeah. And she was saying, well, she's trying to see if she can't say that the child is now a child in need of care because of the emotional damage. Yeah.
Okay. And then just one, the parental rights and responsibilities, could it be between two parents and then a grandparent?
Yeah. So that's the whole idea, was with the parental rights responsibility agreement, that as parents, you can share your rights with somebody else.
Okay. And then just one more question. I have a client who was with a lady for quite some time, and they had recently then split. They didn't marry one another, and he's come to the information that she's now pregnant, and she says that it's not his child. The child has subsequently been born, and he says that the child looks like a spitting image of him. Would I have to do like a High Court application to make her do a paternity test on the child?
You can approach the children's court. Now you asking me quickly about that you can ask for the paternity. Again, if you don't mind, just put your question on the forum, then I can just give you the correct reference.
Great, thank you so much.
Okay. And Sipo, I see your hand was up. Sipo Masibuko. Oh. Sipo.
Hello?
I see the hand. Oh, there you go. Now I hear you. Yes, Sipo.
Yes. I just wanted to ask something. Just a general question. I have a divorce matter. I'm representing the mother. She wants to take her child to a child psychologist so that the child can get used to the new normal, and maybe perhaps the psychologist can then help the child to get used to not to get confused with the new normal situation. The mother's going to bear the cost of all that, but the father's not willing to give consent because the therapist advised that both parties have to sign the papers before the therapy can start. Is there any way that we can do, because we've tried to follow up? It's been, I think, a solid 2 months now. He comes up with all sorts of excuses and he refuses to sign. And we are of the view that it's in the best interest of the child's emotional well-being. What can we do?
Yeah, see, unfortunately, it's an ethical requirement from the psychologist and the social workers for therapy that they need both parents' consent. So your problem lies there. So if he's not going to do that and they don't want to do the therapy, unfortunately, I would then have to do a Form 2 at the children's court and say, bring an application to force him to give consent.
Okay, then I can do that in the children's court.
Yeah, no, you can do that in the children's court.
You said it's a Form 2.
Yeah, there's a Form 2 that you get at the clerk of the court. The mother can, it's an easy form that you fill in, that you can just ask for permission.
All right. Thank you so much.
Okay. Marie, I see your hand was also up again. I don't know if it was up.
I just had a follow-up question on the lady that was asking about the fertilized eggs. She mentioned that there was a court order that same had to be destroyed. Now, is the lady that wants to use them not in contempt of court? Can she or can the father not obtain a follow-up order or do something about it? Because there was an order that same had to be destroyed.
I'll respond. The when they went to the clinic, so actually the clinic is in the fertilization clinic is in breach, but the father subsequently agreed that the mother, or I say the father, as the guy has
the donor, the donor
has agreed that the ex-wife used the eggs, but he doesn't want to have any. He doesn't want to have any responsibilities towards any child that is born from those eggs. So I don't know if that helps your answer, your question.
Yeah, it helps. Thanks.
Okay.
Then I have 2 hands. I don't know if it's correct. Lerato, I see your hand is up again.
Yes, I just wanted to take you back a bit to the unmarried father situation. Those requirements, the maintenance, the upbringing, and do they have to be there all at once, or is it enough to just have one of them, satisfy one of them?
Yeah, I think I always have to go back and read because it says or. So if you read it, it's or. So either he must live with the mother at the time of conception, or so. But then if you read it carefully, they use the word and again at the end of the subsection 2. So strictly speaking, in terms of interpretation, it would have to say that one or two of those must be present, not necessarily only one.
Okay.
But on a very strict reading of the section.
Okay, thank you.
Okay. Okay, anybody else?
Hi. Hello. I just had a question. Sorry, can you hear me?
Yeah, I can hear you.
Okay, I just had a question on based on what two people have said. The first one said that the mother wanted to basically sign over her parental rights in the will if she dies and then it goes to the grandmother. While the second one confirmed that you can have a parental rights and responsibility agreement between the three of them. So if the three of them are in a parental rights and a responsibility agreement and the mother dies, does now the grandmother and the father not hold the parental rights and responsibilities? Does that not do the outcome she wanted?
That will solve the problem. No, that will solve the problem. But I mean, in her, if I understand her scenario correctly, there is no such agreement in place. But if she can in some way manipulate that kind of agreement, it might solve her problem, yes.
That's correct. We did try to navigate that, but the father's not interested.
Okay, I know he's not going to fall for that one.
No.
Okay. Okay. Sorry. Any other questions, Norwu?
Yes, sorry. Just the conversations have got me thinking, and I was just my question is: sometimes mothers will leave their children with the grandmother and go away and disappear, and there's never any formal paperwork done. In situations where both parents are alive and they don't want to give the child up for adoption, like full adoption per se, but they don't live with the child, they don't take care of the child. What options does the grandmother have? Because sometimes then they can't, when they get to the school, if the school is compliant, the grandmother doesn't have a voice. If she goes to the clinic, the grandmother doesn't have a voice. But the parents
I think hopefully when this amendment goes through now, she would be able to go to the children's court and apply for guardianship. But on the other hand, she can also still now go to the children's court and just apply for to be a caregiver. It's not going to give her the same rights as guardianship in terms of consenting to like medical treatments and things like that, but at least will give her some rights. But ultimately, for her to have all the rights she needs, she would need to be the child's guardian. So hopefully, if the amendments go through, she would just have to go to her nearest children's court to get an order.
Okay, thank you.
Okay, good. Okay, can I have the last question? Somebody that I have, Roxanne. Sorry, Roxanne. Yes, Adams.
Sorry, just to follow up with that question, if the child has essentially been abandoned with the grandparents and neither the mother or the father is involved with the child's life, essentially, why can't the grandmother go to the court to have the child declared adoptable? Wouldn't the child be considered abandoned in terms of the Children's Act?
Yeah, you can, but I mean, adoption is such a, it's just a technical, I want to use the very non-legal term of a schlep in terms of social. You have to get a registered adoption social worker who must do a report, who must do this, who must do that, and then you must get these people here and there and next and the following. And I think yes, an adoption is an option, but I just think that in terms of I think where Nobu is practicing and working and doing her job in those rural areas, adoption it's a step too far. Where if you can just actually go to the nearest children's school and just get an order, it's going to be just quicker than the whole adoption route.
Okay, perfect. So I see it's a practical issue. Thank you.
Okay, good. Okay, guys, is that it? Is the one very last question?
Hi. Sorry, can I maybe just ask you a question really quick?
Yeah, sure.
Can you hear me clearly though? Sorry, I'm driving.
Okay, no, that's fine. If you just speak up a little bit, then I can hear you.
Okay, so we had a matter in the children's court where we tried to consolidate matters in the High Court. So the High Court says you must come back when you have a report. And then the other opposing party took it back to the children's court. And they said that the children's court can overturn or overrule the High Court decision. And there's so many advocates that say you can, and then there are so many that say you can't. So I just want to know what's your take on that. Can you actually go to a children's court to overrule a High Court decision? Because they're saying it has inherent jurisdiction.
Yeah, look, I think let me ask you this. So there was a case and the High Court made an order with regards to residency or contact or whatever. And now there's a further dispute, and that dispute has been now referred to the children's court. Is that the scenario?
Yeah, and then the children's court made a decision that overturned the High Court decision. But I mean, you can't do that because the High Court said you must come back when you have a report.
Okay, so the High Court did not make the High Court did not make a final order.
No.
Yeah. See, I think for me the answer, if the High Court made a final order and they said X, Y, and Z will happen, then I don't see why you cannot go to the children's court if there's a further dispute. Despite the order, say the order was made and now there's a new dispute. I don't see why you cannot go to the children's court. But if the High Court did not make a final order, then I don't see how you can go to the children's court, except if the matter that's in the children's court is now a matter of a child in need of care and protection. But otherwise, I would say you have to go back to the High Court.
Yeah, because that's what we said. We said that they're trying to run in two lanes because they clearly don't like the decision in the High Court or the interim decision, and now they're trying to lane hop until they find something that suits them.
Yeah, it sounds a bit like forum shopping. There's a nice case a few years ago that had a very scathing judgment in terms of forum shopping, because I mean you cannot take an interim order and now go to another court before you don't finish your case in the one court first.
Yeah, exactly. Okay, no, that's fine. Thank you.
Good. Okay, sure. Okay, guys, is that it for tonight? Okay, then you must have a wonderful evening. And Leander, please remember to, and Tess also, to just post your questions for me on the forum, then I'll answer you. And yeah, thank you for the discussion and enjoy your evening.
Thank you very much. Good night.
Thank you. Bye.
Thank you. Bye.